Welcome to Division 1 of the Court of Appeals. We have two cases scheduled at 1:30, but I believe you were both contacted by the clerk's office indicating that we would like to combine the oral arguments since they are closely related to one another. So we will go ahead and hear the two cases together and proceed from there. I know you're both familiar with the Court of Appeals procedures, so I don't think I need to go over them. I would just remind everybody in the courtroom that if you have a cell phone with you, make sure that it's turned off so it doesn't inadvertently interrupt us during oral argument. I will remind counsel that there's a toggle switch on the podium that you could use to raise or lower it. And finally, especially since this is a juvenile case, you know that we live stream the oral argument, so if there's any confidential information or referring to the juvenile, please do not use the juvenile's name or the names of any other juveniles. So with that, we're ready to proceed with both oral arguments and people in the interest of DLC.
Good afternoon. May it please the court. My name is Amy Trenery, attorney registration number 46148, and I represent DC. His initials are different in the two cases. I'll just call him DC to make things easier. Based on the consolidation, I'd like to just preliminarily start with the recent turn of events, and I'm sure that the court received copies of the request for judicial notice that I filed on Monday, and I did provide paper copies for the bailiff. The recent addition of a restitution order into case number 574 brings the issues fairly into parity. I'm a little hesitant to agree that they are completely in parity with one another, just based on the fact that the answer brief in case number 574 doesn't address the substantive issues. The appellant chose to put all their eggs in one basket, so to speak, and there is an argument about that in the last section. With that said, I understand, based on the close relationship between the two cases and the fact that the original intention was to bring the exact same issue in both cases as they were raised below, that the court is likely to treat the two issues the same, and so I will proceed as such. Section 19.2, 918.2 requires courts to order that juvenile restitution be paid, quote, in a reasonable manner. That language must mean something. It must give courts some kind of discretion to tailor the restitution payment terms to a particular juvenile's individual circumstances.
Ms. Trenery, if I may ask you, and Mr. McRounds, I'm going to ask you the same question so you can anticipate that. In both of your briefs, you discussed the phrase in a reasonable manner, and your position was that it had to mean that post-judgment interest could be suspended. But my question is, are there other possible interpretations of that phrase?
I thought through what the possibilities could be. Now, in the AV case, which is still a cert pending, the court didn't exactly look at the reasonable manner language, but it did issue a pretty firm holding that this statute does not confer any discretion for courts to consider a juvenile's circumstances when ordering the amount of restitution. And I think that in AV, the court was looking at subsection 1 of the statute. And here, the reasonable manner language is in subsection 2. So what else could that mean? It does cross-reference the adult restitution statutes. But if it doesn't mean discretion to do something about the payment terms, then basically that phrase has no meaning. It's rendered mere surplusage.
Right, well, that's why I'm asking the question. Is there an alternative interpretation of the applicability of that phrase in a reasonable manner?
I can't think of one, and the answer brief did not supply one.
That's why I said that I was going to ask Mr. McReynolds the same question.
I'd be happy to respond to this on rebuttal, and I would like to save a significant amount of my time for rebuttal, especially based on the consolidation. I do think that obviously if you can't look at the base restitution amount, giving that phrase some meaning, and it is not just the restitution has to be paid in a reasonable manner, it has to be ordered to be paid. And so the to be paid phrase modifies in a reasonable manner. And so I think that's where the authority is for talking about payment terms. There aren't a lot of payment terms related to restitution. There is the post-judgment interest. There's also pre-judgment interest, which is required by statute, but unlike post-judgment interest, there's not a particular rate specified. And so perhaps in a reasonable manner, if it were applied to pre-judgment interest, could provide the court with some authority to apply a different percentage of interest there. There are also some terms related to like repayment plans and things like that. So again, it could confer some authority for the court to give a juvenile a little bit more leeway than an adult to create a system that makes it more likely that the juvenile is actually going to be able to comply with the payment terms of the restitution order.
Ms. Trenery, I'd like to ask you a question. You've used the phrase payment terms several times in your presentation here, and you've talked about those payment terms being required to be paid in a reasonable manner. The way I understand your argument, however, in your briefs is that you're arguing that the post-judgment interest on the amount of restitution should be suspended. And the way I understand that, or at least I'm taking that to mean you're arguing that there should be no post-judgment interest added to the restitution amount while DLC is in DYS.
That's my argument.
Okay, so if that's your argument, what does payment in a reasonable manner have to do with whether or not interest should be added to the restitution amount? I see those as two distinct things. A restitution amount, we have $10,000. Now we have to figure out how that's going to be paid in a reasonable manner, but that payment plan, how does it relate to not having interest at all added to the principal?
And you correctly identified that I'm only talking about suspension of the interest while the juvenile is still committed. And the reason for that is that by and large, juveniles do not have the opportunity to have jobs or earn any money. DC is going to school and doing therapy and doing the other things that he needs to do in order to prepare to successfully reintegrate into society. To answer your question, there is a logical relationship between paying the restitution and adding interest to it. The most obvious one is time. Each year that DC can't pay anything towards his interest, 8% annual interest adds up to $4,507. Now, he is committed to DYS for up to 5 years. And so if he isn't allowed to work or have a job or do anything else that would allow him to start repaying that restitution during that entire 5-year period, he's going to end up having to pay $22,000 more than he did when he set foot into DYS. Now, that affects the repayment. In addition,
Certainly it affects the repayment, but wouldn't the statute then require that additional $22,000 and the original amount of that restitution be paid in a reasonable manner? Granted, the interest is going to accrue, but the statute seems to relate to how the payment is going to be made.
I don't think that, my view is that it's not a reasonable manner to accrue interest that someone doesn't have the ability to pay. I understand once he gets out and is able to have a job. The purpose of post-judgment interest is to incentivize a person to pay sooner than later. Otherwise, they can pay 1 penny at a time and the victim has to take what they can get. So, when a person doesn't have any ability to pay, then the function of post-judgment interest just can't serve its function.
But didn't AV, a division of this court held in AV that the changes to the juvenile restitution statute made by the General Assembly removed those ability to pay considerations for determining restitution, at least? Is that
The base amount, but what the legislature did not remove from the statute through the course of 2 different amendments was the in a reasonable manner statute. And so based on the fact that the legislature chose to leave that in there, we have to assume that they meant something by it.
But in the prior statute, the one that was changed, the language was restitution shall be ordered in a reasonable amount to be paid in a reasonable manner. That seems to me to indicate 2 different things. We have a reasonable amount and we have, okay, now that we've arrived at an amount, we have to figure out a way for it to be paid in a reasonable manner. And then the legislature took out the language about a reasonable amount. So obviously that's what AV, the division in AV, was looking at when they reached their conclusion. I'm just not seeing how payment rather than amount relate to your argument about suspension of the interest during the time DC is incarcerated.
Ms. Trenery, following up on Judge Hawthorne's question, do you think in a reasonable manner could be interpreted so that the trial court could order restitution payments based on a juvenile's income?
The way that the juvenile is to make payments toward the base amount, is that your
Yes.
question, Judge Tubman?
Yes.
Yes, I do think that it could. But although there are payment plan provisions in the adult restitution statute, which is cross-referenced.
Right, but I thought you said that those, in your brief, that those payment plan provisions and the requirement for an investigation of an adult defendant's financial circumstances are not part of the juvenile restitution statutes.
In my brief, in the second part of, the latter part of the first issue in the brief, I actually talked about the statutory mechanism for DOC to collect restitution payments from incarcerated adults. And so incarcerated adults have DOC bank accounts of sorts, where the statute specifies that every time they have a deposit into their account, that the DOC is authorized to garnish 20% of that and pay it towards restitution. The problem is juveniles don't have bank accounts when they're committed to DYS. And so there's no statutory match to the repayment for people who are incarcerated to DOC. Going back to your original question, if I'm remembering it, the cross-referenced adult restitution statute does talk about allowing people to set up payment plans. And so that's also incorporated by reference into 192918-2. And so I believe that, again, the in a reasonable manner language, even though the adult restitution statute has very clearly spelled out ways for how that payment plan can be set forth, for a juvenile, because the reasonable manner language exists, it should give courts the authority to have more flexibility with those payment plan terms when a person is a juvenile and their circumstances merit it.
Can I follow up on something you mentioned earlier? You said that the purpose of post-judgment interest is to incentivize prompt payment on the part of the defendant. But the purpose of post-judgment interest also to compensate the victim for the lost time value of the money? And how do we square those two concepts with your argument?
It is. And, you know, I acknowledge that the answer brief contains an argument that the victim wouldn't be fully compensated for their loss without the post-judgment interest. I do think that there is an argument that the post-judgment interest, well, it does serve both purposes that you just mentioned. And I would say that 8% annual interest more than compensates the victim for the time value of their losses. It's what the legislature has chosen for adults at least. And so, again, it provides some room for providing flexibility to juveniles, and especially for committed juveniles who can't work.
But what you're suggesting is that the courts have the authority to deviate downward substantially from that 8% interest. And I'm having trouble, given the cross-references between the juvenile statute and the adult restitution statute, where the authority for the court to, I mean, I guess you're just saying it's from that the reasonable manner language.
Yeah, and not rendering that language surplusage. That has to mean something. And the answer brief hasn't identified what that could be. If it isn't, having some flexibility to make some of the terms of the restitution payment, again, not the base amount, more reasonable if the circumstances merit it. And, you know, in addition to, not the purposes of post-judgment interest, to backing up to purposes of restitution in general, obviously the primary purpose is to make the victim whole from their losses. But an additional statutory reason for restitution is to help the juvenile reintegrate into society. And when they are saddled with $22,000 more debt than they were 5 years ago, that inhibits that juvenile's ability to get back to their life and move on and past the conduct that got them to DYS in the first place. I'd also like to point out, and this isn't something that is addressed in the briefs, although it is addressed in the motion to the district court. Unlike adults, juveniles can discharge restitution in bankruptcy. I think that's an important practical consideration, because if so much post-judgment interest is piled onto a juvenile's restitution order that they can never see the possibility of paying it, that juvenile is much more likely to go to a bankruptcy lawyer, discharge that debt, and then the victim would never be compensated at all.
Ms. Trenery, let me ask you another question. There is obviously an interconnection between the juvenile restitution statute, which contains the language you're talking about, paid in a reasonable manner, and the adult restitution statute, which is applicable to juveniles. And in that adult statute, is the following language: any order for restitution made pursuant to this section is also an order that the defendant owes simple interest from the date of the entry of the order at the rate of 8% per annum. How do you harmonize the position that you're taking about the reasonableness of the payment with the apparent, it seems to me, plain language that says this interest is going to accrue from the date of the entry of the order at the rate of 8%?
I think that comes from the other language in subsection 2, which is in accordance with. And so by cross-referencing the adult restitution statutes, the statute says, shall be ordered to be paid in a reasonable manner as determined by the trial court and in accordance with the adult restitution statutes. Now, the answer brief takes the position that in accordance with means identical, and cites to a dictionary definition, which is agreement or conformity. For me, agreement and conformity are just as ambiguous as in accordance with. And so I actually looked for some other authorities. There were none in Colorado, but where courts looked at the language in accordance with and what that means. Does that mean identical to? And on pages 4 to 5 of the reply brief, I've cited to 3 cases where 3 different courts construing that same exact phrase, found that in accordance with does not mean identical. So the New Mexico Court of Appeals found that switching language from identical to in accordance with softened the language of the requirement. The U.S. Tax Court found that in accordance with it does not mean identical or the same as, but instead it's given, quote, its usual meaning of consistent with. Now that raises another question of what does consistent with mean? And then the Michigan Court of Appeals held that in accordance with is not necessarily synonymous with following or in total compliance with. And so I think that the language in accordance with means that when exercising the discretion to order payment in a reasonable manner, the court should take the adult restitution payment terms, or I know I hesitate to use the word payment terms at this point, but the cross-referenced adult restitution requirements, take them into consideration, but not necessarily apply them letter for letter, but instead take into consideration the juvenile's individual circumstances. At this point, unless there are other questions, I'd like to reserve my time.
I do have another question, and I would just, and you might want to address this more in rebuttal, and that's fine. But I have some concerns about whether, in case 574, the one that you provided judicial notice in, whether the district court actually had jurisdiction to enter the restitution order after the notice of appeal had already been filed in this court.
I mean, I share those same concerns. I don't represent DC in that case, and I have been in communication with this trial lawyer about it. This is something that I did address in the reply brief for 574. I think looking at the plain language of the statute, it raises some questions for me about the 91-day window and whether the court has authority to do that afterwards, not to mention the fact that this court currently has jurisdiction over the case. So it is a very complicated and nuanced situation, and perhaps something that should be addressed on remand.
Okay.
And I'm happy to address it again after the appellee has their say on it. Thank you.
Thank you, Ms. Trenery.
Good afternoon. May it please the court. Kevin McReynolds, Colorado Bar number 40978 on behalf of the people. Rather than jumping straight to the jurisdictional question, I'll start with Judge Taubman's question of what does that term mean? It means what it says, which is it addresses repayment terms. The when and the how of repayment. Paid in a reasonable manner is referring to repayment terms. Yes, the cross-referenced Title 16 sections do have the adult restitution rules regarding how repayment terms shall be, but by including this paid in a reasonable manner language in 19.2, 918.2, the legislature showed an intent for some flexibility on those repayment terms.
Mr. McReynolds,
Yes.
Can you give us an example of how you think that phrase, excuse me, in a reasonable manner might be interpreted? Because I was struck by the fact that there was no suggestion of any of alternatives to Ms. Trenery's interpretation in either her briefs or yours.
Certainly, Your Honor. I think that in terms of the order, if the juvenile was going to be immediately out in society, they could set a payment plan immediately. If there was going to be a period of DYS commitment like there is here, there could be there at that initial point a order that specified how repayment would take place upon release, or if that wasn't done at that time, to be addressed later. It would be within the discretion of the juvenile court or juvenile magistrate in this case to order reasonable terms in which that amount would be paid. The key point here is that it doesn't rewrite the statutes that had been changed as addressed in AV. It does not add back. We're going to have considerations of hardship or reasonableness as to the amount. And that's really, as turning sort of Judge Hawthorne's point, really where defendant's claim fails here is that she's trying to, through the paid in a reasonable manner language, revive the sections the legislature took out that showed a clear intent that there not be separate considerations of ability to pay and hardship in determining the amount. And that's what's being affected here, is the amount that is paid back to the victims to make them whole under the terms as set by the legislature. So with that, I'm going to jump back to the jurisdictional question in the 574 case and sort of the development from the judicial notice that happened this week. This appeal should be dismissed. As the people said in their answer brief, there was no final appealable order regarding a restitution amount or post-judgment interest on some unknown amount at the time that this appeal was filed. And really it comes down to DC seeking review of almost an existential question, 8% post-judgment interest on what? There was no final order. It requires basically, for a final order, an end to a particular action, quote, leaving nothing for the pronouncing court to do to completely determine the party's rights. That's from Curran, which was cited in the briefs. That didn't happen here because the restitution order was requested and it was not ordered at that time. Now, when defendants sought district court review, that district court review motion claimed that there was a restitution order, and that's why the district court ruled on the issue, but that restitution order didn't exist. So as far as this appeal is concerned, the 574 appeal should be dismissed because there was no restitution order at the time the notice of appeal was filed.
But don't we have a final appealable order now?
We don't, but we could in the future. What we have now is the juvenile magistrate has now ruled on the restitution, issued an amount that includes post-judgment interest. If that is in fact sought judicial review with the district court, as is required by CRM 7A, then it could potentially get itself back here. But without that happening, it cannot, because 7A11 of, again, the rules for magistrates provides that is a prerequisite for having Court of Appeals review of the issue. So that restitution order that was issued by Magistrate Peacock, unless it sought judicial review in the district court, cannot come before this court.
Well, I assume it becomes final after a certain amount of passage of time if nobody challenges it, right? I mean, I don't have the rule in front of me, but...
Yes, it does, Your Honor. They have 14 days under, it's actually not under the CRM there, but under the Children's Code, 19.1.108.5.5. For juvenile adjudications, which are under Part 3 of the Children's Code, you have 14 days to seek judicial review in order to and that's judicial review with the district court, in order to then progress to being able to have a final appealable order to present to this court.
So I haven't seen the dates here, but are we outside of those?
No, Your Honor. It was April 24th, so it was last week that order was issued. So as long as that happens within the next week, that would be possible.
Mr. McReynolds, do you think that Magistrate Peacock had jurisdiction to enter the restitution order that she entered on April 24th?
I think that there will be a potential issue of dispute about the 91-day window. There was the request made within that period. Whether or not the court exceeded its authority by not issuing an order within 91 days is an issue that is somewhat disputed here in the Court of Appeals. We have some published and unpublished decisions kind of going both ways on that issue.
What about
yes.
jurisdiction vis-a-vis the notice of appeal and our jurisdiction over this case at this point?
I don't think there's an issue there because of the Supreme Court Sanoff case. Basically, in Sanoff, there was a recognition of, because of the changes that were made to the restitution statute, we now recognize there can be an order without an amount stated in the initial judgment, and then when an amount is later issued and in the Sanoff case, it was issued much, much, much later. When that amount is issued at a later date, that is a separate appealable order. But that's kind of additionally sort of my point regarding the jurisdictional problem with the 574 cases. Under Sanoff, we recognize there's sort of two appealable orders. There's the judgment, which can include an unspecified, we're ordering restitution, the judgment's complete as far as the sentence is complete, and then a separate appealable order regarding the amount of the restitution. But that's two, not three. That's what defendant's trying to have here are three different appealable orders, both, the judgment and an order of restitution of some unknown amount, and any accompanying orders, and then also the amount of restitution as yet another final appealable order. Under Sanoff, there are two. There's the judgment, and there's the amount of restitution final order. And we didn't have a amount of restitution final order when the notice of appeal was filed in this case. And because that didn't issue, now there is one. Now we do have such an order. If it goes through the appropriate process for judicial review, it could then be brought before this court.
Mr. McReynolds, as I understand Ms. Trenery's argument, she's saying that the trial court's judgment of conviction that said, I'm going to order restitution in an amount yet to be determined, but I'm going to include interest because I'm rejecting your statutory challenge, that affords a sufficient basis to challenge that part of the trial court's order, saying the restitution order will include post-judgment interest. Is that your understanding as well?
It's my understanding of her argument, and that's why I think my point on Sanoff is why that's incorrect and why it kind of has to be incorrect, because number one, it contradicts sort of the definition of what a final appealable order is. That did not finally determine all of the parties left, leaving nothing left for them to determine regarding the restitution amount and the post-judgment interest question. Because that, again, we're back to an existential question. 8% interest of what? Of an unknown amount. It leaves the court addressing an interest calculation based on something that may never exist. And if defendant is successful in challenging the Magistrate Peacock's authority to issue the restitution order late, then that would in fact be true, and that would just sort of emphasize the point that the fact that that order exists now reinforces that there wasn't any final appealable order. There is nothing in the 574 case before this court and so there is no jurisdiction to hear it. That appeal should be dismissed.
Well, with the order existing now, the April 24th order existing now, and the question about review by the district court, whether a petition for review will be filed within the specified required time, what do you propose that we do with 574 at this point?
I think that you don't have much choice as to what to do with 574. There was no final appealable order. You did not have jurisdiction to rule on in that case. That appeal should be dismissed.
We haven't ruled yet. I mean,
No.
If I understand your argument correctly,
Yes.
and tell me if I'm wrong, you seem to be saying that the magistrate did have jurisdiction under the Sanoff case to enter this order.
Yes.
And if it's not challenged, if the magistrate's order is not challenged within 14 days by either side, then it becomes final.
It becomes final and unappealable if it's not challenged.
Okay, all right. I missed that second part.
Okay. And that's a function of the fact that it's a magistrate ruling. It is a jurisdictional prerequisite in a juvenile magistrate circumstance to seek district court review within that time period,
Okay,
or else you forfeit the ability to go to the Court of Appeals at all. And sort of in terms of simplifying how we're going to address these issues, I think that, yes, I think that you have to dismiss the 574, but I think you do address the merits of the 575, and that does become law of the case as far as the new magistrate ruling is. If that is pursued as an appeal, if that is challenged, the ruling on the merits on the 575 would dictate at least the post-conviction interest question, or the post-judgment interest question, it would not dictate the result regarding whether or not there is a separate problem with the magistrate order just because of its late issue. So turning back to the statute, the merits, yes, we think that the paid in a reasonable manner has meaning. It has meaning with regard to the manner in which payment is done. It does not affect, in our view, it cannot affect statutory components of restitution as dictated by the General Assembly. The General Assembly did specify we can have some flexibility with regard to payment terms or methodology, but the restitution amount, they've taken that out. The AV case is very persuasive in terms of its plain language reading of those statutory changes. And the in accordance with language in 192, does sort of give us a clear line as to what it is that can be addressed and changed and what can't. And in addition to sort of the paid in the manner, it dictates sort of that those terms which are clear, unambiguous, set forth by statute that are to be the components of restitution are to be complied with, are to be in accordance with. So any order, while it may have flexibility in the payment terms, it does not have flexibility to excise portions of what restitution is as dictated by the legislature.
So, Mr. McReynolds, now I'm not sure I understand the interpretation of 19292 that you're suggesting. Under your interpretation, it applies to, it could apply to payment plans. But if that's so, is there any difference at all between what a trial court judge can do in a juvenile case as opposed to an adult case?
I would say that there is, Your Honor, because part of the Title 16 portion of the restitution does have some specific collections procedures regarding adult restitution, and that would seem to be in the manner of paid in a reasonable manner type of provisions. So I think that that would be consistent with there being something different about how a juvenile court can be flexible with regard to those terms. But in terms of what restitution is, what the amounts are, what the components are, including the post-judgment interest component, which is clear and unambiguous, fulfills a key purpose, overarching purpose of restitution, which is to make the victims whole. That portion cannot simply be excised because it has nothing to do with payment manner. And it would not be in accord, and if a judge were to change that provision, it is not changing something, it is not acting in accordance with the restitution statute in terms of what it defines restitution to be. Are there any further questions?
I think not.
We ask the court to dismiss the appeal in 574 and to affirm the order in 575. Thank you.
Thank you, Mr. McReynolds.
I'd like to start with the issue of whether there's a final appealable order in 574. This is addressed in the reply brief. I want to be clear that what is on appeal here is not the restitution order in 575. The restitution order is sort of inconsequential. There is a completely separate order that was entered in both cases about post-judgment interest, and that is the order that I am appealing, not the restitution order. Now, it has an effect on the restitution order, but the order itself that is on appeal is the order denying suspension of post-judgment interest, not the restitution order itself. And I believe that for that reason, the lack of a restitution order until very recently in 574 is somewhat inconsequential.
But, I mean, the interest has to be calculated on a number, and we don't have that number. And so how, I mean, to me, you're asking us to give an advisory opinion on that.
The court did order DC to pay interest and his plea agreement, to pay restitution. And his plea agreement requires him to pay restitution. The amount had yet to be determined until the court magically fixed that for us this week. Regardless, according to the Attorney General's office, that amount can be specified at any time under the Sanoff case. Now, again, in my reply brief for 574, I do take issue with that. I do think that the plain language of the statute specifying a 91-day window applies not only to the district attorney, but also to the district court or the magistrate in this case. However, I concede that that issue has not been litigated. Mr. McReynolds mentioned some unpublished opinions. I unfortunately don't have access to those, and they're not authoritative for this court. If they do exist, I would love to know what they are because they would provide some very valuable guidance. His question was 8% post-judgment interest on what? And the answer is on the restitution. DC has to pay that. He agreed to pay that as part of his plea agreement. He did not appeal the restitution order itself, except by way of the order refusing to suspend post-judgment interest. He's not taking issue with the amount of restitution he was ordered to pay. He agreed to that when he pleaded guilty in both of the cases. The only question at issue here is the interest. And honestly, the amount that interest applies to, except for if the court decides to reach the constitutional issue where fundamental fairness comes into play, it really is inconsequential at this point. I'd like to also address the jurisdictional issue. I think I already covered some of this, but in the reply brief, I pretty much set it forth. The final appealable order comes from the judgment and sentence that were issued when the plea agreement was entered into and when DC was sentenced to be committed to DYS. And again, part of that judgment is the order on his motion to suspend post-judgment interest. So I don't believe that this is a jurisdictional issue. Separate and apart from that, the answer brief raises the issue of ripeness, and perhaps that one is a little bit closer. But I think my response to it is exactly the same. It's the interest that is at issue. It doesn't really matter what that interest is calculated based on in terms of a base amount. Mr. McReynolds referred to the law of the case, and I simply don't understand how that applies here because we're talking about two separate cases. If this court issues an opinion in 575, that opinion is not law of the case for 574. They still remain two separate cases here and down below in El Paso County. There is, however, an interrelationship between these two, and these are arguments that I made in 574, which I think continue to apply to why the issue is ripe for review at this time. And there are two reasons. First, as I mentioned, DC agreed to pay restitution as part of his plea agreement, and that's in the minute order on page 27 of the court file and in the August 7, 2017 transcript at pages 10 and 24. Regardless of the amount, he's still obligated to pay it. Interestingly enough, his plea agreement does not speak to post-judgment interest. So as part of his contract, his agreement that he reached with the district attorney, he did agree to pay restitution, but he didn't expressly agree to pay post-judgment interest.
Doesn't the statute require that regardless of its appearance in the plea agreement?
Well, that's the question at issue right here, isn't it?
In the adult context, would you concede that the statute requires it?
I do. The second reason is the interrelationship between the two cases, and this is important. The restitution that is payable in 574, which is much, much smaller than the amount that's at issue in 575, is payable, both the restitution in both and all cases, because this is a consolidation of several cases that were dismissed and other counts that were dropped, are all payable as a condition of juvenile parole. That means that DC cannot get off of his parole after the standard 6-month period unless he can pay the $78,000 that is going to be with all of the interest added to the $56,000 that he already owes. And so that is an additional reason why in 574 the suspension of interest is still ripe for review, and it's because of its interrelationship to the other case and how the magistrate tied them together by making the restitution in all of the cases due as a condition of parole. Mr. McReynolds talked about the plain language, the interpretation of the plain language by the division in AV. But I want to be clear that the plain language that was interpreted there is not the language that is at issue here. It's the language of the old statute. In AV, the juvenile relied primarily on the case of ARM. And as the division discussed in detail, the holding in ARM just doesn't matter anymore because the legislature has amended the statute twice since that case was released. And so looking at the changes in that the legislature has made to the statute since ARM, and what remains is how the AV division came to its decision. What the AV division did not address is the language that's at issue here, and that's the reasonable manner language, in addition to the in accordance with language that cross-references the adult restitution statutes. Essentially, the appellee's position is that the statute is unambiguous, and I just can't see how that's possible. The statute in the same sentence says two things: that restitution must be paid in a reasonable manner, and it also must be paid in accordance with the adult restitution statutes. If everything in the adult restitution statute creates a reasonable manner of payment for a particular juvenile, sure, there's no ambiguity. But for a juvenile who is committed, cannot have a job, cannot earn any money, it's hard to see how that equates to a reasonable manner. Judge Hawthorne, I want to go back to the question that you asked me in my first round, and that was having to do with, I think, where we are not agreeing is whether restitution is the amount, or the restitution interest is the amount of restitution, or whether it's a payment term. And looking back to AV, I can't take issue with that case. It's very plain. The base amount, just based on adding up what are the victim's losses, that's the payment amount, the way that I see it. But for me, the restitution is a payment term. Its function is to get that person to pay sooner than later. And for me, that seems more like a payment term than a payment amount. It's added up in money for sure. And so in that respect, it seems like its amount. But really, its function is as a payment term. And when Mr. McReynolds was trying to come up with some examples for how the reasonable manner language might come into play, he cross-referenced 18CA05 and the payment terms that are available there for adults. Well, that seems in tension with his other arguments that in accordance with means exactly the same, because that's the same exact statutory section that is cross-referenced in 19.2.9182. Unless the court has any further questions, I'll ask you to hold that 19.2.9182 grants courts discretion to modify, suspend, or omit post-judgment interest from juvenile restitution orders when necessary to ensure that restitution is ordered to be paid in a reasonable manner. Thank you.
Thank you very much, Ms. Trenery. Thank you, Mr. McReynolds. We Appreciate your fine arguments this afternoon. We are going to order that both sides submit supplemental briefs within 21 days on the issue of the jurisdiction in 18CA0574 based on the Magistrate Peacock's order of restitution. As I said, the parties will have 21 days. We would like you to submit simultaneous briefs of no more than 1,500 words. And we would like you to address whether that order by Magistrate Peacock affects, if at all, whether or not the Court of Appeals has jurisdiction in 18CA 574. Are there any questions about what I just said? We will issue a written order and send it to you either today or tomorrow. But otherwise, thank you very much, as I said, for your fine arguments, and a written opinion will issue in due course. We do have an argument set for 2:30 in People v. Martinez, and I see the council are here for that case. However, we will take a brief recess and come back on the bench at 2:30 because in light of our live streaming of oral arguments, we are unable to start the oral arguments early. So the court will announce a brief recess. Thank you very much. Good afternoon. Welcome to Division 1 of the Court of Appeals. We have one case on our 2:30 docket, as I mentioned before, People v. Martinez. And because we have experienced counsel, I'm not going to review our procedures, except I'll remind you that there's a toggle switch on the podium that you can raise or lower to suit your convenience. I would ask also that if anybody in the courtroom has a cell phone, please make sure that it's turned off so it doesn't interrupt us inadvertently during oral arguments. And last, I would note that, as I think you know, that we are live streaming the oral arguments, so if there's any confidential or private information, that you should be careful as to how you refer to that during oral arguments. With that having been said, we're ready to proceed with the oral arguments on People v. Martinez.
May it please the court, I'm Norman Mueller. I represent Mr. Martinez. The issue in this case is whether, after a sentence is declared illegal, the trial court can resentence, after the case has been remanded for resentencing, to the full range of potential legal sentences, or whether the court is only limited to correcting or reducing a minimum sentence. The answer is, I think Colorado law is clear, that the trial court in this case could have considered and should have considered, but didn't consider, all of the potential sentences in this case, including probation. Instead, the trial court read this court's opinion in the first case involving Mr. Martinez as limiting it to simply reducing or taking off the excess of the illegal minimum sentence. Mr. Martinez had been given an 8 to life sentence. That was an illegal sentence. The sentence should have been, if there was going to be a sentence to incarceration, in the presumptive range, 2 to 6 years as the minimum sentence, but probation was a potential sentence in this case. Indeed, as the court knows from the history of the case, Mr. Martinez had been granted probation originally. It was a stipulated sentence to probation, so there's no dispute that the offense of conviction carried with it a potential probationary sentence.
Mr. Mueller?
Yes,
so
Judge Grove.
This court's mandate in the previous case, it didn't say resentence, it said correct. And I'm wondering if there's a difference between those two terms.
I don't think there is, Your Honor, because I will tell you, when I read that first decision, I said it's a resentencing. It's a resentencing decision, and so I think there is, and this court can be very explicit, and we have in its mandate and to give instructions. And let me think. I'm getting terrible at remembering case names, but let me see if JSR, one of the juvenile cases, where I believe this court held that the sentence was illegal, remanded for resentencing, but gave explicit instructions to the court that you couldn't impose the 1-year mandatory minimum sentence. I think there's another juvenile case, and I think it was JC, again, where I think there was explicit instructions from this court. If there are limitations on what the court can do, this court can say there are limitations on what the trial court, can do. So I'd never even thought of that, Judge Grove, because I certainly, as counsel for Mr. Martinez, never considered that any kind of limitation on Judge Michelson or whoever the trial court was going to end up being.
Mr. Miller, what about the supplemental authority you submitted regarding People v. Isom, where the trial court, or where the Supreme Court rather, just remanded the case for resentencing in accordance with its opinion? That wasn't to correct the sentence, it just used the broad term resentencing.
That's true, and I think the court has used various languages over the time. But if the court did that, then I think I was neglectful in not doing a petition for rehearing in terms of, if this is a limitation that all the court all the panel was doing in Martinez number 1 was to limit and to say, just take off 8 years, but what was the sentence to be? Because number 1, you have a victim's rights issue. Every sex offense carries with it a VRA notification and right. I believe Mr. Martinez had a right to be present at the hearing, a right to allocute. He was granted a new sentencing hearing. And so when there is an illegal sentence, my position is that if it's remanded to the trial court, it reboots the sentencing procedure. And therefore, the trial court, and I cited one of the federal cases that says just that. When there is an illegal sentence and the case is remanded to the trial court, then all available, it's de novo, all available sentencing options are open. And look at the effect on...
Mr. Mueller, excuse me for interrupting
Yes,
you, but
sorry.
what about the language in Abeta versus People, where the court said that where a judgment sentencing one convicted of crime is merely excessive, the sentence is not void in toto because of the excess. It is invalid only as to the excess. And
Well,
that was of course cited and quoted in Hunsaker. And Hunsaker goes on to say that the post-conviction court can correct, which is the language the division of this court used when it sent it back to the district court for correcting Mr. Martinez's sentence. And it says it can correct that portion of the sentence by reducing the bottom end to a term within the statutorily permissible range. So I think correct does have a specific meaning that's different than remand for resentencing.
Well, no case has said that. No case has said there's a difference between resentencing and correction. And, Your Honor, what you need to do, and what this panel needs to do, is go back to the Martin case, read it, go to Abeta, read it and find the facts, and then go to Hunsaker. And here's
Well, you mean the Martin case from
1906.
1906.
That's where the language...
Some of us have read that.
I have too, Your Honor. And so here's what's happened in this, and this is why this, I'll call it confusion, has arisen. In Martin, the issue was the sentence of 12 to 14 years was illegal. Why? Trial court may have applied the wrong sentencing structure, or sentencing statute, depending on the date of the offense. The trial court in that case, in a writ of habeas corpus, had discharged the defendant and had ruled that because the sentence was illegal, i.e. the indeterminate sentence, i.e. the 214 in the 12 to 14 year sentence, had discharged the defendant. So that language arises in the context of a habeas corpus petition. Remember, this is way before any rules of procedure, Rule 35. And so here we have a habeas petition. The trial judge says the sentence is illegal, therefore, essentially, the conviction is illegal. I'm discharging you. That's what a habeas is. You are entitled to your liberty, and the defendant had been discharged. That was all, so that language gets repeated in Abeta. But what was Abeta about? And what happened in Abeta? In Abeta, there were rape sentences of indeterminate nature. There were kidnapping sentences of an indeterminate nature, 30 indeterminate sentences exceeding 30 years. The Abeta court said, no, for kidnapping, it is a determinate sentence. It is a maximum 30-year sentence that can be imposed, and it must be determinate. And then they cite the language from Martin and say, well, it would be easy. Maybe we could just remand for imposition of the 30-year sentence because that's the maximum legal sentence. But they didn't do it. They remanded the case, saying, well, now we've got the combination of the indeterminate sentencing statute. We should defer to the trial court. Essentially, without saying this much, we, the appellate court, are not a sentencing court. That's why we're sending it back to the trial court. Now, we get to Hunsaker. Well, Hunsaker was my case. And what happened in Hunsaker was there was no dispute on count 1 that there was an illegal sentence. So the second count was the pattern count. And in that case, the trial court had agreed with my argument that since there was no extraordinary aggravating circumstances, that sentence also was illegal. But remember, we filed a 35A motion. The trial court granted the 35A motion. We had a resentencing hearing. So we had a full sentencing hearing. Victims' Rights Act was complied with. Mr. Hunsaker was present, and we had the hearing, and it was a mandatory sentence. So probation wasn't even an option. So with that resentencing hearing, after the successful 35A, the trial court said, I'm going to reduce the minimum sentence in this X to life sentence under the Sex Offenders Act.
Are you suggesting then that, so let's take Bassford, and Bassford's got this long discussion about lopping. So are you saying that, as I read it, Bassford suggests that the appellate court can just do the lopping itself?
I think it depends on the case. I think Colorado law is quite clear that there are two potential remedies for an illegal sentence. And one, depending on the nature of the sentence, the nature of the illegality, an appellate court could correct that by lopping off the sentence. But this court didn't do that.
Well, let's look at the nature of this case then. You're saying there are two different possibilities, and one is that the appellate court could lop off the excess that makes the sentence illegal, right?
I would say, no,
I
I'm
thought
not.
that's what you just said.
No, I said it depends on the case.
Depends on the case, and that's what I'm saying. Look at this case with Mr. Martinez, and there's an excess because it was outside the appropriate range, and all that needs to be done is lop off that excess, right?
I disagree.
What calls into play a total resentencing and a consideration of probation and any other kind of resentencing considerations?
Under a case like this, where probation is a legal sentence. When the trial court imposed an illegal sentence. And so when there is an illegal sentence, there might be cases where, like in Hunsaker, where there was an excessive minimum sentence, but it was a mandatory sentence. We had a resentencing hearing. Even in that case, in Hunsaker, we went back and we argued what is the appropriate sentence. Now, ultimately, the Court of Appeals and the Supreme Court agreed with it, that it was still a mandatory, it was still an aggravated sentence, and reinstated the sentence, the original sentence. But when we did the 35A, we had a resentencing hearing.
But that's when you did the 35A.
Right.
Right? And the 35A was subsequent to the Supreme Court decision in
No.
Hunsaker.
Before it. That's the whole background of getting us to the Court of
I'm
Appeals.
sorry, not 35, I'm talking about 35B.
Yeah, 35B
Right.
In that case. But then, yeah, Hunsaker gets complicated because then it's a crime of violence and
Right.
you're entitled to
Right. But the Supreme Court says in Hunsaker that sentences can be illegal in different ways, and the nature of the illegality dictates how courts correct those sentences. And it sure seems like Hunsaker is very similar factually to this case about being in excess of the appropriate range, and all that needs to be done is lop off that excess.
Well, I don't disagree with that general language, Your Honor, but that's nothing more than a general acknowledgement that depending on the case, depending on the nature of the illegality, there can be two possible remedies. And in most cases, appellate courts remand for resentencing because the appellate court does not want to be a sentencing court. And in Hunsaker, we had a resentencing hearing. We didn't have probation as a possibility because it was a pattern count, so it was a mandatory minimum sentence no matter what. And it was only after that And in that case, yes, if we'd wanted to seek probation, then you'd have to file a 35B. Look at the judicial economy issues in this. If a case is being remanded for resentencing in any event, and in this case, it's a compelling case. 16 years on a touching case. I mean, I detailed all of that, all of those issues that the trial court wouldn't even consider because it didn't think it had power to even consider probation. So, as a bottom line, when there is an illegal sentence, whether it be, and in this case, an excessive minimum sentence, when probation is a legal sentence, my position is, and I think the law is very clear on this, that when there's an illegal sentence in the cases, and it's going to be corrected by the trial court, it's sentencing de novo. It reboots. And I have 23 seconds. So I'll reserve that time, or if there are other questions, I'll obviously answer them.
No, that's fine, Mr. Mueller. Thank you.
Thank you.
Good afternoon. May it please the court. William Kozlowski, registration number 37824 on behalf of the people. The issue in this case is whether Judge Michelson was correct in concluding that the previous division's mandate was simply to remove the excess prison sentence, and therefore probation was not an option at the resentencing hearing. No matter the answer to that question, this court should affirm. If the answer is yes, obviously there was no error and this court should affirm. If the answer is no, because the court found at the end of a full sentencing hearing that it believed the proper manner for a defendant to be released back into the community was through the parole board, then if there was error, it was not consequential, and the record reflects that he would not have granted probation.
Mr. Kozlowski, let me ask you about your second alternative that you just mentioned. If Mr. Mueller is correct that there's a new sentencing hearing, wouldn't that mean that Mr. Martinez would have an opportunity to present allocution and additional evidence to the trial court that it did not?
No, sorry. He did. This was a full sentencing hearing. Mr. Mueller and the defendant were allowed to present everything they wanted to present. And then at the end, the court said, I don't think I have authority to impose probation, but as a footnote, even if I did, I wouldn't have. This was a full resentencing hearing. So the question is, what is the previous mandate? So this issue was fully briefed in the previous appeal. I said there didn't need to be a resentencing hearing. Mr. Mueller said there did. So the remand order was, on remand, the court must correct Mr. Martinez's sentence in accordance with Colorado law. And Judge Grove, to your question, I considered making that argument that correct meant something different than resentence, but then at the end of the opinion, it says the case is remanded for the district court to resentence. So it says both. So
let me follow up on
sure.
that. Here's my concern with Hunsaker and a lot of the other cases. That the language that those cases use is more hortatory than mandatory, right? They say it can be corrected by doing this, or or it could be, and it never says must or shall or anything like that. And so that seems to be to possibly leave open the door to Mr. Mueller's argument that this is an option, lopping off is an option, but that the district court still has the option of going the other way, and that is doing a full resentencing hearing. And the core of his argument seems to be, to me, that the court erred by saying, no, I don't even have that, I can't even consider that.
No, I agree that's his argument. I guess two answers. First, as a legal matter, and it's more of a practical and common sense approach, the initial denial of probation, there's nothing flawed about that, however long it was. He was sentenced to probation, and that's my argument set out in my brief, that it's a windfall to the defendant. That these are the defendants where a judge says, not only do you get prison, you get prison beyond what I'm legally authorized to do. And the court doesn't do that on purpose, but your offense is so serious that it goes beyond. It makes no sense that you go back and say, well, we'll consider probation again. And that's just a practical argument. But I think the main issue in this case is, what did the previous division mean when it said in accordance with Colorado law? And it cites Hunsaker,
Right, well, that's why I asked the question, is in accordance with Colorado law, uses those cases use the languages like can and could.
No, obviously I agree, but I think Judge Michelson was obviously trying to figure out what he was supposed to do. He obviously should do what he thinks he's being told to do, and under the new rules, they cite to the particular paragraphs 33 and 34. Sentences can be legal in different ways. If a sentencing court imposes a definite sentence in excess of the statutory maximum, the sentence can be corrected by removing that excess. I feel like Judge Michelson was appropriately concerned that that was this court telling him what to do.
But is there anything in that case or in Bassford or any other case that says that the court is foreclosed from considering alternatives other than lopping?
I don't think there's anything that says that, but I think if you read the previous opinion and then read Hunsaker, Judge Michelson was correct in concluding that is what he was being told to do. I think it is from the context of the opinion, and then it goes on to cite Abeta, which is what the Supreme Court relied on in this exact, going back to Hunsaker, it was this exact count. It was an SAOC count. They said it was an extraordinary risk. It wasn't. Mr. Mueller says it was a mandatory prison sentence. It was a mandatory prison sentence because of count 2, not count 1. And count 1 was, the trial court did exactly what happened here. They just took off the excess. So, it's our position that Judge Michelson was correct that this court told him to do what he did. Obviously, it's up to this court to decide what was meant previously. But even if he was wrong, the record reflects that Judge Michelson would not have granted probation. It's, quote, "I don't believe probation would be appropriate. As flawed as it is, it seems that the appropriate place for Mr. Martinez to get his release is through the DOC treatment and parole board reviews process." And his statement that as flawed as it is a reference to all of the information that Mr. Mueller and the defendant presented at the sentencing hearing. He presented the case for mitigation, why he deserved probation again, and it's a little troubling that Mr. Mueller says that this is just a touching case and that the defendant needs another chance at probation. The record fully supports the trial court's statement that probation was inappropriate. The history of this case is long and tortured, as they say, but the defendant was adjudicated on a sex offense for giving a 7-year-old boy $10 to perform oral sex on him. During that adjudication, he had 3 opportunities for treatment. He failed at all of them. As a result, he was sent to youth corrections, where he committed this offense. In treatment, at that time, he admitted that he had 33 victims. The PSI recommended that probation was not an option. The district attorney decided to give the defendant one more chance. Within 3 months, he had violated probation. He was sentenced to prison. Once again, there's nothing flawed about the original trial court's decision that probation was inappropriate at that time. Then Mr. Mueller says that the defendant is, quote, becomes lost in the system at the sentencing hearing. I think that is better characterized as unable to complete treatment. He had 2 opportunities in prison to complete treatment. He failed at both of those. So although the trial court's statement at the end of the sentencing hearing is short because it had concluded that it didn't have authority to impose probation, it said it didn't believe probation was appropriate, and that is fully supported by the record.
Mr. Kozlowski, I'm not sure I understand what the implications of our ruling in this case are. As I understand it, both sides have said that if we affirm the trial court here, that Mr. Martinez can file a 35B motion. Is that correct?
Yes, Your Honor, I don't even, I guess, to address your question, I believe the main legal argument here today is largely academic, because I think this trial court could say, I don't believe I have authority to impose probation under the Court of Appeals mandate, so I'm imposing a prison sentence, but under my authority under 35B, I hereby reduce the sentence to probation. I could have done that at this sentencing hearing. I mean, there is a procedure to get to probation here, absolutely, in the exercise of the court's discretion. If there are any other questions, we ask that you affirm. Thank you.
Thank you, Mr. Kozlowski. Mr. Mueller, you have, according to our clock, 13 seconds.
People versus Rice means that if the court misapprehends the scope of its sentencing power, the remedy is to remand for resentencing. This court didn't think it had power to impose probation, so that's why we should get a new sentencing hearing.
Thank you, Mr. Mueller. Thank you again, Mr. Kozlowski. We appreciate both of your fine arguments in this case. A written opinion will issue in due course. That concludes this afternoon's oral arguments for Division 1. The court will be in recess, and the bailiff may so announce.